Mic check.
Good evening. Welcome to the St. Helena Planning Commission meeting for April 5th, 2016. And I'd like to ask Commissioner Monette to lead us in the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Roll call, please.
Commissioner Koberstein,
Present.
Vice Chair Kistner,
Present.
Commissioner Monette,
Here.
Commissioner Sweeney's absent, Chairperson Parker.
Present. Moving on to public forum, this is an opportunity for the public to address the Commission on items of interest to the public that are not listed on tonight's agenda. Because of restrictions imposed by the Brown Act, the Commission may not engage in discussion nor take any action on matters not described on tonight's agenda. Please observe the time limit of 3 minutes. Would anyone like to speak at public forum?
Jeff Ellsworth, Sylvaner Avenue. I'm just trying to come to meetings at the beginning of the meetings and on the county level and the city level as well, and just mention that in our county we have the highest rate of cancer for children in the state, and for adults it's the second highest. So we're asking our appointed and elected officials if we can start getting a push to understanding what is creating that. So I just want to bring that up. Thank you.
Thank you. Would anyone else like to speak at public forum? Seeing none, I'm going to close public forum and move to our consent items. We only have one item this evening. It's the approval of the minutes from our March 1st and March 15th meetings. Do we have any revisions or a motion?
I move that we approve the minutes from March 1st and March 15th.
I'll second.
So that was a motion by Commissioner Kistner and the second by Commissioner Koberstein. Roll call, please.
Vice Chair Kistner,
Yes.
Commissioner Koberstein,
Yes.
Commissioner Monette,
Yes.
Chairperson Parker.
Yes. Moving on to our public hearings, we have two this evening. Our first one is the consideration of amendments to our St. Helena Municipal Code short-term rentals. May we have a staff report, please?
Thank you, Chair Parker. The item before the commission tonight is a proposed revisions to the short-term rental ordinance. And specifically, these amendments are to Municipal Code 17.134 and are intended to create a renewal process for current short-term rental permit holders, modify the review and operational criteria for short-term rental permits, and improve enforcement mechanisms. And these changes were directed by the Planning Commission and City Council in their review of the short-term rental ordinance in the fall and winter of 2015. Just to start with some background on this item, the short-term rental ordinance was originally passed in April of 2012. It allowed 25 short-term rental permits to be issued by the city. Then in June of 2014, the City Council reviewed the ordinance to provide direction on some unanswered questions. Staff brought it back primarily to address the fact that there was no renewal structure set up in the ordinance at that time, and all of the permits that were issued in 2012 were set to expire. Shortly after, or about a year after that, the item was brought before a town hall meeting here in this room. There were about 80 attendees. There was a general mix of support and opposition for the short-term rental issue. And there were significant requests to prohibit all short-term rentals at that time. The item, staff brought the item back on November 17th of 2015 at a public hearing before the Planning Commission to receive direction. And then further, the Planning Commission's input was taken before the City Council on December 8th, 2015. Also at a public hearing to receive further direction and finalize what those changes should be for the ordinance to be brought back before the commission and ultimately the council. And you may recall that at that time, staff provided 3 options for the ordinance revisions: repeal the ordinance in its entirety, modify and improve the current ordinance to improve the mechanisms for review and enforcement, but maintain the 25, or to increase the number of short-term rental permits that were available at that time. And the direction was to modify the ordinance and bring it back for revision, and that was unanimously supported by the Planning Commission and the Council at both of those public hearings. At that time, staff had also initiated some other enforcement improvements. We were trying to improve and enhance our responses to complaints that we receive on short-term rental issues. We had entered into a contract with a company called Municipal Services, who reviews and provides some services to cities on a variety of issues. And then we'd also, separately but on a parallel track, initiated some revisions to the code enforcement process citywide to try to make some of the penalties and mechanisms for enforcing code a variety of codes throughout the city. And just as anecdotal information, last fiscal year, short-term rentals brought in approximately $144,000 in TOT to the city, and that's based on an average occupancy rate of 34%. This is a location map of the current short-term rentals. It's kind of hard to see the exact locations that was provided in the staff report. There are approximately 10 on the west side and about 12 on the east side currently, so they're pretty evenly split on either side of the highway. And it is worth noting that we currently have 21 short-term rental permit holders operating. You may recall that some direction was provided to staff to hold off on issuing any additional short-term rental permits or those renewals as we got close to this process. So staff has done that, and currently we have 21 in operation. So throughout the process, there was a variety of public outreach that was done, and numerous comments were received from the public, as discussed. There was a summary of all of the comments received at the town hall meeting attached to the staff report, and all written comments received on the short-term rental issue were also attached to the staff report. Generally, the concerns resolved around noise and traffic in neighborhoods resulting from short-term rental operations, unknown individuals and empty homes being in neighborhoods, and those are generally the negatives. But we also did hear some support regarding short-term rentals having benefits to the city, providing TOT, providing a relief for folks who want to come stay in St. Helena but do not stay in hotels, etc. Similarly, as mentioned before, staff had brought some changes forward to address staff needs essentially. So there's currently the ordinance requires that applicants provide a lot of notification on their initial submittals to neighboring residents, and staff doesn't have any way to verify that information is provided. As mentioned, there has been no renewal process formally codified into the current ordinance, and then also there's a waiting list that the city city staff has created, but it's not formalized, and there's some kind of questions regarding how that's to be formally implemented. Currently, it says that all folks on the waiting list actually file their applications, pay their fees, and they're reviewed by staff. That's seen as an inefficient use of both staff resources and application fees. So staff has proposed to make modifications to that process. In reviewing the short-term rental ordinance, the Planning Commission provided a number of directions, but essentially a summary of those would include to increase owner involvement in and accountability in short-term rental operations, and explore opportunity to provide short-term rentals to St. Helena residents only, improve enforcement mechanisms and methods on all short-term rental regulations for permitted and unpermitted operations, minimize some of the impacts of clustered short-term rentals or kind of their proximity to each other and the number of them in neighborhoods, and then finally to improve and explore methods for revoking short-term rental permits. Further, the City Council provided a number of directions, but also wanted to kind of enhance the current local contact and response times, increase enforcement, create a minimum amount of ownership time of a home before a short-term rental permit could be issued to a property owner, increase fines and penalties for some of those folks who are violating the ordinance, create a limitation that if you are verified to have been, or if a property owner is verified to have been operating an unpermitted short-term rental, that they will never be allowed to have a short-term rental in the city. Limit the number of guests on site, explore a local preference policy, prohibit all events on short-term rentals. Currently, events are not prohibited, so that's become an issue as identified by some residents. Publish the permit number. That's currently a requirement, so staff, but there was some direction that it wasn't occurring, so we strengthened the language there. And consider revising the review process to force all new short-term rentals to come before the Planning Commission, include residents as well as owners in the notification process. Currently, there are only property owners are notified, and then explore a use it or lose it option, meaning kind of have a minimum amount of time or rental activity that's required in order for a short-term rental owner or permit holder to be able to maintain their short-term rental operations. Of course, there's a lot more nuance and detail to that direction. However, that's identified in the staff report, and so the summary was provided just as a brief overview. So in response to all of the information that was received from the citizens at the town hall meeting, through the staff analysis that was done and kind of the issues staff has with implementing short-term rental ordinance, direction from this body as the Planning Commission regarding some of the concerns and changes that the Commission would like to see, and what the City Council directed staff to do. Staff has prepared revisions to the ordinance and brought them back for your review and consideration, and ultimately a recommendation onto the City Council as to whether or not the City Council should approve these revisions. And I'm just going to go through them. They're identified in the staff report. I will identify them by code section. A red line strike-through version of the ordinance itself is attached. And so I'm just going to go through these briefly, and I'll be happy to answer any questions after we're able to address these. So the first change is to modify section 17134040H to include a requirement that the contact information for the local contact person is posted and available on the city's website. Staff found that the requirement that they be available to the city or to the site within 30 minutes is adequate. However, there was no mechanism to ensure that the information was available and provided to neighboring residents. Modify similar, also the same section, but letter J and K to completely prohibit all events and parties at short-term rentals, and also limit the number of folks who can ultimately be at a short-term rental. That's 2 per bedroom plus 2. So that would be the number that's identified in the code. modify the same section but letter M to strengthen the requirement that owners ensure their renters do not create disturbances. The language now says to their best ability or something to that extent and it has now been modified to say owners shall ensure that renters maintain and meet the requirements of the current ordinances. Or they could result in direct fines, penalties, and ultimately revocation of the short-term rental. Same section, letter M, has been modified to strengthen the requirement that a short-term rental permit number be included in all advertising, as mentioned, including electronic advertising. Same section, letter P, has been modified to implement a local preference policy. The result of that, should it be supported and ultimately approved, would be that current folks who are currently on the short-term rental waiting list could be skipped over if they were not a local resident and skipped over in favor of issuing or at least reviewing a short-term rental application for folks who have an address in St. Helena currently. There is a requirement to, based on the council direction, that ownership must be of a home for 3 years. The PowerPoint and the staff report say 2 years, but I'm sorry, it's 3 years in the ordinance. You must own your property for 3 years prior to being issued a short-term rental permit. And the direction from council on that was to minimize folks trying to build in short-term rental revenue as an element to how they would make their mortgage payments on purchasing homes here in the community. Also, there's a proposal to add section R to create a requirement that individual permit holders rent their property on a short-term basis for a minimum of 60 days per year. This gets back to the use it or lose it. That's staff's attempt at creating a use it or lose it provision. Essentially, there's been some pushback from current residents or property owners who are concerned with that. Like as I mentioned, currently the average occupancy rate for short-term rentals is 34%. 60 days per year would result in a 16% occupancy. So it's just information for the commission to have in their review. There is some modifications to section 17134060 B to provide the planning director more discretion in referring individual short-term rental permits to the commission. Same section, but letter G is the prohibition on folks who have known and verified to have operated a short-term rental without a permit to prohibit them from receiving short-term rental permit approvals. And then letter S is intended to limit the proximity and density of short-term rental activities currently occurring within any one neighborhood. Specifically, that requires that a separation of 600 feet between any two short-term rentals on the same street, and I believe 300 feet in a general, not on the same street, but in any direction, you could not have another short-term rental permit issued. There are also a number of revisions to address the concerns identified by staff with regards to the noticing issues, the renewal process, the waiting list, et cetera, as previously discussed. And then finally, it's worth noting that all of the revisions are intended to be forward-looking. They're not intended to be retroactively applied. So if a new permit holder, a new permit was reviewed, they would be subject to the density limitations and the ownership issues, et cetera. But if it was a permit holder who's currently been approved for a permit and is coming up for renewal, they would not be subjected to the density issues, the ownership issues, et cetera, as they were previously approved and have ownership over their current permit. However, their renewal would be subject to the renewal requirements and the enforcement mechanisms that are being modified to improve and enhance the staff's ability to enforce current regulations and ultimately revoke short-term rental permits if it ends up that these folks are not able to comply with all the regulations. As I mentioned, we received a number of public comments throughout the process. All of the ones previously received prior to the preparation of the staff report were attached. Generally, a majority of comments came in before this staff report was prepared. However, 2 comments did come in on this staff report, on this item prior to staff report preparation. One was to eliminate the use it or lose it provision, and another had comments and questions over kind of what we're doing currently to enforce short-term rental permit efforts. Since that was issued, a few other comments have come in. They've been provided to you at the dais, and there's There's hard copies available in the back for the public. But essentially, the majority of them were requesting that the use it or lose it provision be removed. That seemed to be a big concern for current permit holders. And then just getting into the issues, as I mentioned, if we implement these changes and the council ultimately approves them, some folks on the waiting list will be skipped over, primarily in favor of the local preference policy. And then, as I mentioned, renewals as well as new permits have been put on hold subject to the revisions. And I will say that we are having some success with ongoing efforts to enforce regulations regarding both permit holders and unpermitted short-term rentals. At one point, I believe there were 60 notices or advertisements for permit short-term rental operations in St. Helena. Within the last month, I think we checked, and there were less than 10. So I definitely feel we've had some significant impact on those listings. However, they fluctuate, they come and go, and so it's not a hard number, but I do feel we are having some success. However, there is no funding specific to enforcement or code enforcement in the city, so it will be an ongoing issue that staff will have to address, but I do feel that we've been able to make some progress, and with these revisions enabling the staff and the commission to revoke short-term rental permits for folks who are not compliant, we will be able to continue to improve the enforcement mechanisms. So given that, it's requested by staff that the Planning Commission review the proposed revisions to the short-term rental ordinance, provide a recommendation to the City Council as to find if the project is exempt from the requirements of CEQA, identified in the guidelines provided on this slide, as well as in the staff report and the ordinance, and then also review and accept the proposed revisions to Chapter 17-134 of the St. Helena Municipal Code, recommending to the City Council approval of the revisions and adoption of the ordinance to implement the revisions as previously directed. That concludes my presentation. I'm available for any questions.
Thank you very much. Are there any questions?
I have a question. What happened to the idea of getting a bounty hunter for the illegal rentals? And they were going to be paid by a percentage of the fines collected. And I thought we were hiring someone to do that. I'm wondering what happened to that, and if that's still a possibility to be able to enforce these beefed up ordinance.
So as a part of the review of the Commission's recommendations, the City Council did not endorse dedicating any specific funds to enforcement mechanisms of the short-term rental ordinance. I will say, however, private investigators are currently being utilized in our enforcement efforts.
So there are, you have done what that idea, I mean, you have realized that idea that the bounty hunter system would work, because it wouldn't cost the city anything. They would only get a percentage of what they collected. I mean, I don't understand, is that happening? Or
That's not how it's currently happening. The city currently uses a private investigator as a part of our enforcement efforts. However, that is not on a bounty basis. It's paid for their time, and it's a part of the enforcement mechanisms. The council did not provide any direct funding, and we did not go through a process whereby bounties would be used to pay the staff who were doing that work.
Is this private investigator being paid by the fees collected, the fines collected?
Coming out of the general fund, same thing.
Or is it coming from someplace else?
The general fund funds the enforcement efforts for the private investigators. However, we have received significant settlements in 2 of the cases that we've ultimately litigated.
Is his fee based on a percentage of that, or it's not? It's okay.
Completely separate issues. One is used to determine who is a violator, if they're actually a violator, and then the city attorney's office manages the negotiating and settlement for essentially payment of penalties and fines, the civil penalties portion of the ordinance as it currently exists.
Thank you.
Know how much turnover is in this? I mean, we started in 2012. How many new permits have we issued, and how many people have we lost? You got any idea? I mean, is it big?
It's small. I think we've lost 4.
Okay.
And we've issued 2, maybe.
Yeah, so we're not talking about a lot. Thank you.
Yep.
And then just a clarifying question, I don't really need to go into details, but this has been vetted by our city attorney for all of the new additions.
My office worked pretty extensively with
Okay.
with Mr. House on this. Yeah.
All right.
I have a couple questions. I didn't quite follow. At one point, you said that the current TOT is based on 34% occupancy, and then I think you used occupancy again when you talked about the 60-day. Can you explain exactly what that meant? I didn't quite follow you.
So current TOT, basically currently the entire, an average of all of the short-term rentals are rented on an average of 34%.
34% of the
Of the year.
365 days of the
Yeah,
year?
that's correct.
Okay.
60 days, which is currently what's in the ordinance, would be 16% of the year.
60, okay.
So the direction to staff was explore a use it or lose it provision. Staff was trying to come up with a number that would be appropriate, given that some folks, it's their primary residence and they don't rent it all the time. Others, it's essentially purely a vacation rental that is rented as a short-term use more than they're even there. And so given that the current average is 34, staff felt that 16 was an appropriate place to start
Okay.
the discussion.
Yeah, I thought you said 60. And then I have one other question. It's not clear to me how you're going to be able to manage the waiting list if you're not looking at anything until the point arrives when there's an opening. Are people really on the waiting list? Have they submitted anything to you? How do you know who's on the waiting list? And how do you know that they even could comply, like it's a resident who's been here for 3 years?
So there is a list. People are on it. It's been maintained since before I was with the city. It's ongoing. It's essentially first come, first served. They give us their name, their address, contact information within an email, or it's actually typically an email. I asked for it, so we have it as backup. They're added to the list. The list is maintained on the city's database on the server, and we keep it. And as far as knowing whether or not they are will meet all the requirements of the code, we don't until we get it. There was a person who was first on the list who came up. They submitted an application. It was deemed they had no off-street parking, so we let them know that they weren't eligible for a permit, and they were removed from the list at that time.
Okay, so do you give them a certain length of time to get the material to you? So you
Yeah,
can-
yeah,
okay.
absolutely.
Any other questions? All right, with that, I'm going to open up the public hearing. Please leave if you could have your comments be to 3 minutes and minimize them to not repeat what people say before you, just so you can use your 3 minutes to the best of their potential.
I'm Kathy Brotmarkle, 503 Fulton Lane. My husband David and I are short-term rental permit holders. And first of all, I want to thank Noah and his staff for your extremely thorough, time-consuming, and thoughtful work on this issue, all the proposed modifications and additions. It's very evident that you listened to all the complaints and the suggestions, and it's very admirable what you have done. David and I are in complete agreement with everything you've proposed except for one item, and that is the requirement for permit holders to rent their property for a minimum of 60 days per year. If they do not do so, their permit renewal could be recommended for denial. This requirement is also included in the proposed addition of a renewal process. We understand this is in response to the use it or lose it comments at previous meetings. Last year, we rented our home for approximately 30 days and will likely do the same this year. Our home is our full-time residence. We do not own a second home. We've lived here 26 years, and we work hard to maintain the unique character of our neighborhood and our city. We rent out our home when we're away, and we make plans to be elsewhere when we have an opportunity to rent it. Having to rent the home for a minimum of 60 days would be very problematic for us. We believe renting our home for 25 or 30 days a year lessens the impact on our neighborhood and maintains the character of our rural, quiet area. Most of the complaints aired at the previous meetings involve rentals with too much coming and going and a loss of neighborhood character due to busy rentals. We are the opposite of that. In addition, for us personally, 95% of our rentals are for 3 nights. Typically, we rent Thursday to Sunday. So if we had to rent our house 60 days a year, we would be renting our house every other weekend. We don't get rentals of 2 weeks or a month or 3 weeks, in which case we could just rent our house 3 times and we'd hit the minimum. 3 days is the typical rental. So We believe we are model permit holders. Most citizens, I think, would prefer people like us over an out-of-towner who buys a second home and rents it out 200 days of a year. We're residents. We've owned our home 21 years. We're current with our payments. Our business license, have never had a complaint. We would like to suggest a couple options. Either remove the requirement or lessen the number of minimum days to maybe 25 or 30. In the same section, possibly include language that exempts permit holders from the requirement if the home is their primary residence. And I understand you're using the 34% occupancy as kind of a guide, but you're comparing a few of us who do live in the home and rent for 20 or 30 days to that outer-towner who owns a second home and he rents maybe 200 or 300 days a year. So there are extremes, and so to say 34%, it is a tough one. Anyway, thank you so much for your efforts.
Thank you,
It's
Mrs.
very much
Brooke-Markle.
appreciated.
Hey, howdy, Jim Sweeney, 1407 Kearney. One thing worth repeating is you guys have managed this process totally so well. I know it's self-serving for me to say that, but very delicate in a small community and just managed with real grace. The items I'd like to suggest for review by the Planning Commission is item L, where the word verbiage has switched from the owner applicant shall, use best efforts to now the wording is shall. And I just feel like it's going to be very prohibitive. I think that if somebody is out of town, we certainly have the person on call. We have the phone number and the person identified on the website, but that's very prohibitive kind of language. And what we're asking is that you move back to best efforts, and then during the renewal review process, that will expose itself through the police department or neighbors that are coming in to appeal the process. But I'd like you to consider relaxing that, and then in 2 years, if in fact we're not pleased with that, then come back and possibly strengthen that up. The next item, is item Q, where the ownership is being moved to 3 years. Clearly, we've owned our home for a period of time, but one thing to think about is as you're prioritizing the homes that are available, there could be a young family in which we as a community desperately want to move here and may want those 30 days revenue to come in and prop them up while they bring their kids into the school system. I don't know how you really want to look at that, but I'm not saying that that family should be buying the home based on securing a permit. However, if there's 3 or 4 permits available, we have a young family that's lived here 2 years and nobody has filed for those permits, the council or the planning commission may want to look at possibly making that permit available to that young family, assuming that they're young. And then the next item is that the 60 days, I'd also like to support Kathy. She kind of iterated everything for the reasons that those should be there, but even if somebody rents it every other weekend for a year, you still don't hit the 60-day hurdle. And so I'd like to also support a 30-day. That does satisfy the use it or lose it. And then, as you saw, the average is very high. Forcing that up to 60, you're still at a number of 34%, which is really strong. But we as a community would like to recommend it come down to 30 or some number, whether it's in-home or not. But a 30-day is really a strong number for many folks. Thank you.
Thank you.
I'm Carolyn Kilparis. I live on Main Street in St. Helena. Basically, I just have a clarifying question. Item S, the very last sentence, say renewals of permits issued prior to April 5th, 2016 are exempt from these limitations. As I read this, the limitations are just in that paragraph. I thought I heard Noah say that the renewals are not subject to the ownership requirements. So where I sort of have a question is, if an out-of-town owner requests a renewal and there's local owners on the waiting list, who takes precedent? Thank you.
Yeah, so the renewals would be permits who are previously issued, who folks are operating, and they have a permit. So whether they're a local resident or not, the local preference policy is only intended, as it's currently written, to apply to new applications. So currently, folks who are operating legally with the permit, whether they're a resident or not, would not be subject to that.
Thank you.
Maybe that sentence, renewals of permits issued prior to April 5th are exempt, should be sort of a separate line rather than lumped with that paragraph.
Thank you very much.
Jeff Ellsworth, 1434 Sylvaner. I just wanted to bring up on the enforcement issue. I don't know if it sounds like there's some, you said detectives that try to find out what's going on. I just want to make sure that, should the enforcement be paid for by the people benefiting it, and should there be a special mechanism? Because one of the things that I heard over the last months when this was coming up was that people would call with a complaint and there wouldn't be any prompt action. And they were going through night after night of bad nights with parties and disruption next to their residential home that they invested in. That was their investment in residential zoning, and to have this commercial use, disruptive commercial use. And I'm not saying that not all visitors are disruptive, but I think that we have to have a policy of not one more bad night for neighbors. That they know that they can make a phone call that night, there will be an immediate response, and there's money set aside for that, so that, within 7 minutes, there'll be an enforcement officer making sure that the rules are being enforced and that the neighbors are protected. Thank you.
Thank you. Would anyone else like to speak by public hearing?
Good afternoon, good evening. I would also like to commend city staff on by the way, my name's Matthew Demchuk, 1702 Tanner Street. I am a short-term rental permit holder whose permit has expired, but I am in limbo with awaiting the renewal of my permit based on these revisions. And I do commend the staff on what they've done. I think they've taken everything and lumped this all as best they can to do. I just had a couple issues, or a couple concerns, couple comments. I think the penalty in enforcement, definitely, I think all of us permit holders are in favor of enforcing against the illegal permit holders, but I do think we need to distinguish between the illegal enforcement provisions and the legal enforcement provisions. And I think that right now the way that the penalties are set up is that the illegal providers would be penalized $1,000 a day, so would the legal permit holders. And I really think that there should be a distinction between these two, and that the legal permit holders would potentially have an opportunity to have kind of a graduated, fine system, as opposed to immediately imposing a $1,000 fine on a legal permit holder because they had a renter that violated the guest house rules. The other thing is on the 60-day minimum. One of the suggestions that I've heard circulated was possibly, instead of having a night minimum, maybe having a TOT tax minimum that it's generated by that rental property. I don't know if that's an opportunity. And then the last issue that I had was in regards to the proximity provision. Because mine is actually within these limits, I'm aware of that, but I think that there should be a case-by-case basis. I mean, there's notice provisions in the ordinance that allows neighbors to comment and oppose any application that's submitted. And I think that there shouldn't be a moratorium on permit holders within 300 feet. I think it should be a case-by-case basis, that if there's enough discussion and enough concern about it, that maybe then it get brought in front of the Planning Commission, as opposed to just a stringent provision that prevents any short-term rentals from being within 300 feet. So those are a couple of the comments that I have. Thanks.
Thank you very much.
So my name is Nancy Parrish. I live at 1096 Crane Avenue here in St. Helena.
Speak to the microphone.
Sure. How about that? Can you hear me now?
Thank you.
You're welcome. So just to clarify, the numbers of STR permits is not being recommended to change from what it had been in the original. Is that correct? So just to address the 60-day versus a shorter time period, I can get what some of the current permit holders are saying, how that would affect them, and I can appreciate that. However, having attended some of the meetings regarding when this was being discussed, it seemed that one of the big reasons why we even allow short-term rental permits in this city at all, and there were a significant number of people at the city council meeting, I think it was City Council in this room a few months ago where that came up, that really preferred no short-term rentals. But that sort of went by the wayside. But it seems that one of the reasons for allowing is based on the TOT. And so it would seem almost that if that is one of the reasons that we're allowing it, that their 60 days does not seem to be excessive. 30 days is a short time, and so I guess I just am thinking after hearing everybody that maybe there might be some benefit to the overall population of the city versus the individual short-term permit owners themselves, if in fact that should be the 60 rather than a shorter time based on the staff recommendation. Yep.
Thank you. Would anyone else like to speak on this issue? Seeing none, I'm going to close the public hearing and invite commissioner discussion.
You want to go?
Who would like to tee off?
Okay. I think I'll put a couple things on the table that we can maybe talk about it as a group. First, regarding the renewals. Apparently, we don't know how many permits are held by residents and how many are held by non-residents. I did go through the little list, and just by looking at the letters that had come in from people, I could identify that about half were non and half were residents, but that's only based on 9 or 10. But assuming that's a decent sample, maybe half of our permits right now are held by non-resident owners. And I personally think that was one of the overriding issues that we discussed the first time around. And one way to handle it, I think, would be to establish maybe a percentage goal, that overall it's the goal of the city that, say, 75% of the permits be held by residents. And maybe a non-resident owner would be entitled to one renewal, but after that, if the goal had not been met, the city could deny the renewal and start moving down the waiting list. Otherwise, you sort of have a permit for life, and we don't have any real mechanism to reach the goal of resident operation unless somebody kind of voluntarily drops off. So that's one thing. Second, regarding enforcement, I'm wondering if we can have some kind of security deposit or bond put up by the operator to guarantee compliance with the noise issues. You know, I view this as when you rent a rental, you usually put up a security deposit that you're not going to damage any furniture. I'd like to see maybe a second deposit put up by the tenants that would guarantee compliance with the house rules, so that there might be a pot of money, either something that the owner posts at the beginning of each year or whatever, that would be readily available to the city to deal with some of these noise problems. Because it is an enforcement issue, it does cost money, and otherwise it seems like the only way you get the money back is to use the TOT revenue or start fining people and go down that route.
Did you say I thought you said that put up by the tenants. Did you mean the tenants or the renters?
I would say that would be one way to do it, is to have the owner have their tenants also put up a security deposit guaranteeing compliance with the house rules.
I would imagine that there is a security deposit on VRBO and Airbnb. I know that that's typical for short-term rental situations, but I understand what you're saying is a bond of the owner to the city, which that's not a bad idea. I mean, for most permits, you have a trucking permit, you have a bond from the insurance company.
I think most security deposits generally deal with damage, to property. I don't know that they deal so much with living by the house rules, but I think it might be worth looking at. On the permit process, I just had a couple of questions. The council recommendation had been that the Plan Commission also review all renewals if the person had a history of some violation. I don't know if that was meant to be encompassed by your sort of catch-all number 3. But I believe they also said that all new applications should come to the Plan Commission, and I didn't see that in
Yes,
here.
I
The
recall that.
direction was to consider that. Staff did not require all new permits to come before the planning commission. We kind of did a blend. There is, as you mentioned, there's one area where it gives the planning director more authority at their discretion to recommend some, and then there are some others, such as the area where the user will lose it. If you're less than 30%, or I'm sorry, if you're less than 60 days, then that triggers a review by the planning commission. So there are other triggers built into the process that requires the short-term rental renewal to come before the commission, but staff did not build in a requirement for all new permit holders to, or all new permit applicants to come before the commission or renewals. Just given because the administrative process is currently working well in instances where there are no problems and there aren't any neighborhood concerns, so that was what staff was thinking in that.
Okay. And lastly, on the ones that do come to the commission, I personally don't find the use permit findings real helpful. I think it's very hard to deny an application based on the findings that we're faced with here. And they would often come to us if we have an abundance of neighbors who are upset and complaining. And I would encourage the staff or the council to come up with perhaps another standard that is going to go more to the kind of issues that we're going to be facing. And I personally, I think the last comment about the separation was a good one. My initial view was that there should be a blanket prohibition of a certain distance between them. I do think that there might be room to bring those to the commission and let them be considered, but there's got to be some standard. But I would also, instead of drawing a 600-foot boundary and a 300-foot boundary, I would just draw a radius around the property of 300, 500 feet, because somebody, backyards adjoin each other, and if you're going to be bothered, that's who's going to be bothering you, not so much somebody 300 feet down the street.
Yeah, I wondered about that too, if it was as the crow flies.
I've got that also on my list.
So there was some thought put into the linear 600-foot and then the 300-foot radius. Staff looked at what a 600-foot radius would do, and looking at some of the more compact historic neighborhoods, from the staff's perspective, there would be little opportunity for some of those folks to have impacts on each other, because some people are around the corner maybe 10 yards away from each other, so 10 backyards. So a 600-foot radius seemed excessive, but then if I drop the linear footage of the radius, so down to 300, then that didn't get to some of the neighborhood proximity issues with having two on the same block. One way to address that may be to just require, if they're within this certain distances, to bring those before the commission at a public hearing, as you mentioned.
I'm sympathetic to this 60-day thing. This is the last thing I'm going to say, and then I'll be quiet. I think it's at odds with the goal to have resident owners. And I think there's a conflict there. I understand the desire to maximize TOT, but I hate to think, when I look at the numbers, in order to get to the 34%, that means a lot of these people are renting their places 120, 150 days a year, and they must be the non-resident owners. I'd like to come up with something that serves the resident owners better than the 60 days. I think it's a little bit too much.
I agree with you. I actually liked Mrs. Markle's idea of exempting it if it's your primary residence. I
I
think
do
that is the easiest solution of if it's your, and you can figure that from tax records.
Yeah, I wrote some stuff down because I don't speak well off the cuff, but apropos to this particular question, the ordinance, as I recall, was initially requested by homeowners to legally rent out their homes when they were on vacation. and residents were very concerned about the impact of this plan on their neighborhoods and the quality of their life. And in order to address this problem of illegal STRs and to accommodate the modest time requests at the time, there were very modest time requests, just vacation of the residents promoting the ordinance was passed. The prospect of STRs as a significant source of money for the dwindled city coffers was not an issue then. And that has spurred interest in this phenomenon primarily as a revenue generator for the city, for the general fund. And given the risks to our neighborhoods and the quality of life, which I don't think has a price on it, and the sense of safety, I do not think that it's a prudent public policy to incentivize commercializing our neighborhoods to balance the city budget. And therefore, I propose that the following language be placed number 14, explore the implementation of a minimum use to retain a permit to be 21 days a year. That's 3 weeks vacation. To be reviewed at the time of permit renewal. I believe that a limit on the maximum number of days rented is more important than on the minimum days. And 2 months of the year, which is a fifth of the year, is a lot. And so I was going to also say I would like to see the 60 days be the maximum number of days for short-term rentals, and people who are going to be away for significant periods of time, more than that, have the opportunity to rent their places for 30 days or more. It's not like they're not going to be able to rent their places at all. But 60 days seems reasonable for short-term rentals. So if that were, so I'm in agreement with that. If that were changed, there are several places where that would, I'd written those down, but I don't need to say that. So I agree with that. Also, when the short-term rental ordinance was first predicated, it was the main reason for it was how to deal with illegal short-term rentals. That's how it came up. There were 81, I think. Alan did the research. There were 81 short-term rentals, illegal short-term rentals, because all we had was an ordinance against them. So the idea was if we have an ordinance that legalizes them, then we'll be able to have the revenue to enforce get rid of the short-term rentals, and people will then have this opportunity for permits. And it wasn't very well thought out, in terms of enforcement at the time, but that's how it started. So I come from that perspective, and I don't see this ordinance as a revenue source for the city other than to get enough resources so that the TOT can be used to enforce the illegal STRs and to enforce people who have legal STRs who are violating ordinances. So to me, it just seems, I don't know if it's legal, it seems like the TOT should go as much as needed to the enforcement of this ordinance, and anything that's left over should go to the Affordable Housing Fund, because I think this whole process is, to some extent, taking some available housing off the market for people to live in. So I don't know if that's legal, but that just seems to me to be kind of obvious, to take that money mainly for enforcement. And I think I heard at our last hearing there was a lot of support for that, or at least a lot of expression for the same thing. So if that, I don't know if that's legal, but if it is, I think that seems pretty reasonable to me. Then I had some other stuff, if you can stand it. I was wondering, you had on page 2 of the Exhibit A, you had number E regarding number 6. This is in reference to number 6 of the City Council directions, 17-134.040. I would like to have that changed to 3 bedrooms from 5 bedrooms with a maximum of 8 people per rental. And I think that was the feeling of the City Council when we were talking there, that 12 was too high. So, and then on page 3 of that same exhibit, on number J, I would like to change 7 a.m. to 8 a.m. simply to be consistent with all the other morning start time ordinances in the town, as to my knowledge, for working and for, leaf blowers and other items. I don't know why it's 7 a.m. That seems early. That's on page 3 of the under J of the appendix, or what it was called. Okay, so and then on page 4, of the Exhibit A, number M, again, referring to J3 above it, I thought that it might be a good idea to add parking to the list of unreasonable disturbances in that paragraph, because it was a big problem, and when I remember when we had the big meeting, it came up several times. So it might be a good idea to spell that one out in number M with reference to J3. I mean, it seems to me that those two go together. And then for number Q, or letter Q, I suggest we spell out 5 years. The choice was between 3 and 5 years, as per number 3 of the City Council's direction. I think there were lots of arguments given for 5 years, or some arguments anyway, at the City Council meeting, as I recall. And then I was going to ask you for number R on page 5 of that. Because I didn't realize there'd be so much mature. I thought I was really off the rock. Oh, never mind. So I already said that. I thought I was going to be the only person who thought we should make the 60 days the maximum and lower the, but that's already happened. And then for S, again, my question was, is that as the crow flies? So, oh yeah, and then on page 6, letter B, number 11, referring to number 11 of the City Council's directions, I think that, and also the testimony at the big meeting, I think that all initial STR applications should be automatically reviewed by the Planning Commission, simply because there's been so much public outcry and a sense of, the system's not working. I think that the public may feel more confident if they know that whenever there's an application that's come up, I don't mean, when it's come up from the waiting list, that they will have a chance to come and speak out, that it will be before the public. So I think every initial, not renewals necessarily, but every initial application for an SCD should come before the Planning Commission, simply because, not because we know so much, but simply because that gives an opportunity for public input. And then there was a typo. I don't know if you're interested in it. But there's another thing, and this I think I'm going to be, this is my last thing. Are you interested in the typo? No? Okay. I'll let you know later. I had this idea last time, but I don't think it's very popular, certainly not with permit holders. But I wanted to say that in order to have a fair and equitable opportunity for as many St. Helena citizens to be able to augment their income by turning their homes into STRs for up to 21 days a year, I propose that a waiting list be a roster for a rotating process that would allow 2 permits. Every permit holder could have one renewal, so it would be something you were suggesting for out-of-towners. But 2 or maybe 3, but I was thinking 2, so everyone could have 4 years. And then after that time, they'd go to the bottom of the list, and others who were waiting, who were qualified, would come to the top of the list. This will discourage people from purchasing a home in St. Helena that could not otherwise be financed without commercializing it as a neighborhood hotel and having a forever and ever and ever permit, as Commissioner Koberstein mentioned. And it would also distribute the opportunity for extra revenue to as many St. Helena residents as possible, sharing rather than concentrating that wealth. And I think it's part of the tradition of St. Helena, and it's a direction that I'd like to see us go in, of sharing wealth rather than concentrating it in a few hands. So I'm just throwing that out there as an idea, since we're looking at ideas. So I think that is it for me. Thanks. I don't know if you guys want to respond to any of that.
Commissioner Kistner?
You want my list?
I want your list. I'm writing down all the
Okay.
lists so we
All
go
right.
through all of them so
Excellent.
you
Okay.
can.
I'm going to go through your strikeouts, all right? And I'd like to start with 13440 B. Where you're saying one person may hold no more than one short-term rental permit. And I would like to include in that sentence anywhere. We've had, in the last year, we've had 2 people that have come here that have had short-term permits, not only here, but in England and in France. France. And to me, that's a business, and I don't think that was the intent of this ordinance, was to have this a big business. Okay, so I would like to see that changed. And then, on the same page.
I'm sorry, I wasn't quite clear on that direction.
All right. I would like to say that if you're going to have a short-term rental in St. Helena, that's the only one that you have, that you don't have one in St. Helena and one in Paris and one in London. Now, we've had two of those that I know in the last 2 years, and I think we've denied both of them, but I think we should make that perfectly clear and not waste your time with even processing them if that's what they're trying to do, is form a business with short-term rentals.
I understand. It's uncertain how that would be enforced, but
I don't know how you enforce it, but I think that we need to look at that. Okay. Also, on C, a short-term rental uses shall be limited to a single-family dwelling existing and constructed at the date of application for the short-term rental. Does that mean that I can build a house and tomorrow I can apply for a short-term rental?
as it's currently written.
And that is in deep contrast to Q on the applicants for short-term rental permits are required to have owned their homes for a minimum of 3 years prior to applying for and being issued a short-term rental permit. Now, I'm not saying that 3 years is right, but I don't think that I should be able to walk into town, buy a lot, build a house, and put a short-term rental on it. Okay, I mean, that bothers me. Okay, on the next page, I have a difficulty with E, in which it says, the number, wait a minute. Yeah, E, where you're allowing 2 times the number of bedrooms plus 2 persons up to a maximum of 12 people. I think if you're allowed two persons for 2 bedrooms, that's enough. And I'm not sure that we have any 5-bedroom homes in some of the smaller neighborhoods, and I certainly hope that we wouldn't allow 12 people in some of the neighborhoods around, particularly around the core of the city. Let me see. I'm in agreement with Commissioner Koberstein that as a part of the housing policies, that we should include a security deposit that the renters would pay and would be forfeited to the city if there was a requirement, if there was complaints of against any of the things that are in this ordinance, and that the deposit would be forfeited to the city toward the general fund, so that we are paying for the actions that have to be taken. And K, JK, that's on the next page. I think that we should say auctions, weddings, commercial functions, and other similar events should be prohibited, period. I don't think we need to go into all the other stuff in that.
That was specifically recommended by the city attorney's office to address the definition of event. So it provides some prescriptive limitations versus, a card game, a dinner party for the folks who are staying.
I'm not having a problem with the auctions, weddings, commercial functions, and other events. I don't think that we need this statement in there, which have the potential to cause traffic, parking, noise, or other problems. I think that we should say no auctions, no weddings, no commercial, and that's it. I don't think we have to explain what could result if we have these things in these homes. In L, I'm going to laugh at myself at this one, but I really have a problem when you indicate violate the provisions of this code or any state law pertaining to noise, disorderly conduct, the consumption of alcohol, which I don't know how in the world you're going to enforce, or the use of illegal drugs, which is against the law. So I think we should strike those words. I mean, I'm not sure what that means. I mean, if I'm renting a home someplace and I want to have a glass of wine with my dinner, I would assume that that's okay.
It is
And if
okay, you just can't be loud about
If I get drunk and disorderly, then I have an idea that the police will be called and I'll end up in jail. So I think that that's just redundant to put that in there. In M, again, I'm going to talk about the security deposit. I think that that there should be subject to fines and penalties, and the loss of the security deposit that would go to the city. I'm talking too much tonight. R is
The 60-day.
page 5. Okay. Yeah, I think I agree that the 60 days is not fair. I think that we should encourage the residents of St. Helena, if they want to do short-term rentals, regardless of how many days per year they want to rent it. And I agree with Mrs. Brotmeyer in that I like the idea of it's got to be their primary residence. I think that's. I was trying to think of something, Kathy, that would fit that. I'm very happy that you got up and said that tonight. Well, again, oh, wait a minute. I'm reading the top of the page here. Yes, I think that we need the diameter around the house and not a 60-foot linear. I mean, that's what we use even here with how close we live to something, and I think we should. And I don't know. May you say 600's too big, and 300's too small? Maybe you do 450. I don't know, but I think we could look at that. C4 on the page 5. C4. Yeah.
Certification?
What?
C4 certification?
No, I think that that if we would make this as a local person is eligible for their short-term rental, I don't think it has to totally be St. Helena. I think maybe Upper Valley would be better. And then I would think that the owner would be the one that would be responsible to have someone in the area to take care of the things. I just feel that maybe St. Helena's too small, and I think Upper Valley's good. I don't think we want to get messed up with Napa or anything, but I don't know. You guys want to get messed up with Napa? And I agree with my fellow commissioners here that all new applications should come to us. And the last thing I have is then the renewals. I think that non-residents, other than the Upper Valley residents, shall be granted one renewal and be given notice that if he or she applies for an additional renewal, the application will be placed at the bottom of the list of residents applying for a permit. I think you'd call that a sunset clause. And that's all the comments I have right now.
So I guess my question is for you, Noah, do you want us to go through all of those again to get everyone's opinion, or how do you want to handle this? Because it seems like we added a lot.
How I was imagining is that each commissioner would voice their individual concerns, and then staff would go through and identify the ones that multiple commissioners or a majority of the commission has identified as issues. I'll summarize at the end. You can tell me if I got it right or wrong.
Okay, all right. I definitely am in concurrence with the business of the short-term rental, only one permit. I know would be hard to enforce, but you only get to have the one short-term rental here. You can't have one in Paris. You can't have one in London. I know it would be difficult, but yeah. What else did I like? I did like Commissioner Koberstein's, the residential focus of the renewal process, where there's a percentage of the short-term rentals we want to try to get to a number. I think maybe 75 might be a little high, but something where we try to get those, and then the waiting list isn't so, can be a little bit more flexible. Definitely on board with a security deposit from the renter, but also a bond from the owner. I think that just makes sense. If you have a permit, you have a bond. That's just the way I have a car, I have insurance. I definitely like the idea of getting rid of the 60-day minimum and having it be if it's the primary owner's house. The primary owner is exempt from the 60-day. I also like that there's a planning commission hearing for every application, not to toot toot beep beep, but because I want to hear from the neighbors. I'd like the idea of lowering the maximum number of guests. I'm in agreement with the clustering and it being a diameter, not a linear. And I don't know how we're going to work the 3-year minimum, but I think that that's for owning the property for 3 years, I think it's touchy, but we need to kind of iron that out.
Is there any, I'm just curious, is there any buy-in from anyone else about the TOT, using the TOT in the way I was suggesting for enforcement and affordable housing fund?
As I identified, that was a previous recommendation of the Planning Commission to the City Council, and the Council chose not to direct staff to implement that with their previous review.
So I don't think we need to be redundant and ask for it again if they're just going to come back and say no.
Okay.
That's why I think this is security deposit.
Yeah.
And if we have to enforce it. And a bond, I didn't think about that.
A bond, yeah.
I agree.
We can't ask them twice?
You know what, you can, Bobby, as a private citizen, but I don't want it to come from the.
You don't want
yeah.
to do it as a.
I don't want it to come from the Planning Commission.
And what about the rotating, a rotating list so that there would be a minimum number of times? I'm the only, I think that maybe Commissioner Cooperstein kind of touched on that, but does that sound like a fair, something to explore?
I think it sounds fair because this is really a license. It's a privilege that you're giving to people, and to allow just a small group of people to sort of lock it up indefinitely doesn't seem fair. So, I mean, in addition to putting something in the renewal process to try to reach, a certain threshold of resident owners, I think that there should be something that there's no guarantee that you're going to continually be renewed, so that new residents in particular might have a chance. I have a general TOT question. Is the city, I thought that Commissioner Monette raised an interesting point, that these people who are renting 120, 150, 180 days a year, they might be renting for 30 days at a crack, which doesn't really...
They're not considered a short-term rental if they're renting for over 30 days.
Right. Do you collect TOT from them?
They do not pay TOT. They're not subject to it if they're rent for over 30 days.
It's a monthly lease.
Do people pay a general license fee in addition to the cost to cover the application review?
They have to carry a business license with the city. Business license costs are based somewhat on the value of the business or the income of the business. In addition, the renewal, I think, the renewal cost is intended to function as that mechanism, I believe.
Okay. I wanted to talk about one thing that Grace mentioned in the 040, the section B, about one person may not hold more than one short-term rental permit. I think you have to go beyond one person, because you could have one person who is a member in this limited liability company and that limited liability company and that limited liability company, and they could own 4 or 5 short-term rentals. So I think...
I'm sorry, I laugh because you remember the Big Rock Road? Yes.
Okay.
70 members.
Yeah, I think you got to clarify that in the B section there, so that you cover that.
So I'm going to go through what I heard, consensus from the commission, and the commission could give me direction. I would like to add, some of the intention of making these revisions was to address unenforceable elements of the code currently that staff has no ability to enforce, and also to improve the functionality of the current regulations. So just to clarify that, and it should be in your minds as you're thinking about direction to staff as to what changes should be made. So I'm hearing a consensus on the 3-year minimum ownership whether it's of the home, so whether it's you build a home and then 3 years from that point, or whether you purchase the home, it's 3-year minimum ownership of the home, not just the property. Consider reducing the maximum number of people who can occupy a short-term rental, and I heard ideas of 3 bedrooms and 8 individuals.
Could I interject something? I mean, that may be a case where we could automatically send something to the Plan Commission if it's a bigger house. You know, I think 3 bedrooms is kind of maybe an average of what you find in a lot of
But
neighborhoods.
what my sense was, oh, go ahead, finish.
I just think if it was an application for a 4-bedroom or 5-bedroom, it might come here so that you could kind of look in the specifics and look at what neighborhood it's in, and, you know.
And that could be addressed with just the maximum occupancy, regardless of bedrooms, is X individuals.
There might be some places out in the hinterlands where they have 4 and 5 bedrooms, and it's not an issue. No.
I also heard explore a security deposit to pay for city violations of short-term rental and other policies and regulations.
That's kind of a security deposit bond.
Yeah, then there also is the bond.
Direction has been, it's consensus from the commission that 60 days is too high of a minimum. However, it may be appropriate if there's an exemption considered for folks whose their short-term rental is their primary residence. The separation between existing short-term rentals should be based on a measurement of diameter, not as it's currently written. And consider if rather than prohibiting them within that density, consider requiring the Planning Commission to review them at a public hearing. I also heard consensus for all new applications to come before the Planning Commission. And then I'm hearing consensus to explore the ability to get to a certain percentage of local ownerships for short-term rentals. And then also to consider limiting renewals in general to a maximum number
Of years?
of renewals. So yeah,
Okay,
so
of
or
renewals.
years, either
Yeah,
way
okay.
it was written, but yeah. And so I will say some of these, again, the intention is to address illegal operations, and you know, I know the council voiced some concern over or limiting the maximum number of renewals, given somebody may get a permit, make a lot of investments in it to make it function as a short-term rental, and then if it's going to go away, then that may not occur. So that was a discussion point of the council. However, that's what I heard consensus on from the commission. Can the commission identify any other issues that?
Well, I'm wondering, did anyone else agree with me that the 60 days should be a maximum?
I don't agree with that. I think that there needs to be a balance between the minimum and the amount of money that.
Do you think there should be a maximum at all?
You know, I think if it's a problem,
Yeah, if it
it's
becomes-
going to manifest itself somehow.
Before it gets to the
And we'll get at it
maximum.
maybe through the enforcement
Yeah.
issues or a non-renewal.
I agree with that.
But, you know, I do feel kind of strongly about this renewal issue and bringing the residents up to the top and establishing a certain percentage. I mean, I agree, this was about enforcement and that, but it was also, I think, a suggestion of the council to, you know, look at ways of having most of these, or a lot of them, held by St. Helena residents, and that seems to me to be the logical way to do it.
I mean, but it could also happen is if we do decide to, if our city council decides to limit the number of renewals you can have, and then residents have priority on the waiting list, then it's going to happen naturally.
What do you mean by a percentage?
Having a certain percentage of the short-term rentals be residents in St. Helena, not outside people who own property here.
You know, as a goal, like, you know, and it's up to the city council to pick out these numbers, but let's say they want 2/3 of the permits. The goal is to have 2/3 of them held by city residents who satisfy the 3-year requirement, or however many years the council decides it should be. Until you've hit that number, I would say that a non-resident doesn't get an automatic renewal. You know, and that you're trying to bring people up through the waiting list who would shift, you know.
So the goal would be to get everybody be a local person.
Or a certain
Or a certain
percentage
percentage.
as decided by the council.
Okay.
And the idea behind the local ownership, as a reminder, is that folks, you know, if you're an owner or a resident here, you're more accountable to your neighbors. You see each other in the grocery store.
everywhere.
You know who folks are. And so you're more likely to be a
There's
better
less
operator of
violations
your short-term rental.
And less issues.
Right. I mean, that was the whole idea about local press. And, if we just keep renewing automatically, we're not going to achieve that, I don't think.
Right, and I think that even if you do invest something in which you might want to do, it's a 4 years. 4 years is, and if this council thought maybe 6 years should be better, but I mean, it is and I do think that that rotation. You didn't say anything about a rotation, but what did you guys think of that idea that you have? After a certain number of renewals, whatever the council wants, that you go to the bottom of the list again.
I have considered limiting renewals to a maximum number.
Okay, but then
That creates they can put their name back on the
They
list.
can choose to
They can
reapply
choose to, or they
so
don't.
that's
or
just
not.
obvious. People are going to get that the next person will go.
Yeah. All right. Perfect. I think that's it. Do we need to have a motion?
Yeah,
on our
motion, roll call vote, please, on the
Okay.
recommendations. There is not a resolution for this recommendation. However, the minutes will reflect it if we do a motion and a roll call vote.
May we please have a motion, please, for our recommendations?
Can I ask a question?
Of course.
I don't think we want to bring this back here. You want a recommendation for us to take it to the council now? With the-
100%.
With the,
As
with the changes you just talked about.
That's right.
So moved.
Second.
So that was a movement by Commissioner Monette and a second by Commissioner Kistner. It's a mouthful.
For the council to adopt
For the council to
draft
adopt
ordinance
our draft ordinance with our recommendations.
with the recommendations.
Commissioner Monette,
Yes.
Vice Chair Kistner,
Yes.
Commissioner Koberstein,
Yes.
Chairperson Parker.
Yes. Thank you, everyone, for coming out and voicing your opinions. They're very much appreciated. Yeah, we'll clap for you. And if you would like to stay, you're about to see some procedural magic. So we're about to have some procedural magic right now. Yeah, we're gonna take a quick 5-minute break. Reconvene at 25 after. Welcome back. Continuing on to item number 6, a public hearing to consider a recommendation to City Council concerning proposed amendments to Title 17 zoning of the city's municipal code. We have our city attorney here to help guide us through this procedural maze that we have created for ourselves with recusals. And we teeing off with you with the staff report to explain to us what we're doing, and also Victor Cornelia as well too.
Happy to start. Thank you. So what we have this evening on this second item or third item on the commission's agenda is a series of issues under California's conflict of interest law. It was adopted in the early 1970s by the statewide voters as known as the Political Reform Act. And it is the law that imposes on all of our elected and appointed officials financial conflict rules that prohibit council members who have, or appointed commissioners who have certain recognized financial interests from participating in certain decisions that will impact their financial interests, either in a positive way or a negative way. And so tonight on this, on this decision now coming before the commission, this law, the Political Reform Act, is now coming into play for some of our members. Specifically, there are two decisions that the commission will be making now. One is with respect to the use permit requirement for the so-called opportunity sites in medium-density residential districts, and two is with respect to the use permit requirement for
requirement
entirely within the high density residential district. There are different commission members, I understand, who either own or lease property within either within the high density district. I believe there are two commission members. That will, for both of them, they will have a conflict of interest with respect to that decision for the high density district. There also, I guess, are two commissioners who own two or three who own property within 500 feet of the designated opportunity site properties for which the commission is being asked to make a decision for medium density districts. And as to those, the commission members also have a conflict of interest. Now, different rules apply under the Political Reform Act for each of those conflicts. With respect to those commissioners who have conflicts because of their proximity to the opportunity sites within the medium density residential district, there is a process or a procedure that the Political Reform Act allows and recognizes known as segmentation. It will allow the commission to segment each of those decisions for each of the specific properties for which there are potential conflicts. As to each of those votes, individual commission members will recuse themselves. The rest of the commission will will vote on that property, and then the other commissioner who had been recused on the first one will then come into play for the second vote on the other opportunity site property, and then after that is those two votes are taken, then the full commission will vote on the remainder of the opportunity sites. That's the way segmentation works. You eliminate the decisions for which there are conflicts first, and then the full commission can vote. It gets even more convoluted and difficult now as we move on. With respect to the high density use permit requirement decision that you'll be making, we have two commission members who have financial conflicts for which recusal is required. But were that the case, because Commissioner Sweeney isn't here this evening, that would eliminate the commission's quorum. Because these decisions have to be made under the city's housing element by a date certain, what's known as a rule of necessity applies. That means you have to make a decision tonight on this. Because you have to make a decision, and the city is under a fairly rigid schedule imposed under the housing element, it's important that you make the decision. When that is the case, the Political Reform Act allows the conflicted members to essentially be selected by a random process, drawing straws, picking a number, like that. And by doing that, the two conflicted commission members will determine which one of them is recused and which one of them must participate in this decision. And once we draw the straws, and one member then who is recused leaves the room, then the remaining three will make the decision on the high density use permit rezoning issue or zoning text change. Is that muddy as can be, or
No.
does that clear it up? Okay.
I am going to make the one note, though, just, I do believe that Commissioner Mona is also recused from 591 McCorkle, so I'll just include that with the 567 Pope Street that she's also recused from, if that's okay with everyone? All right, perfect.
Yes.
I just checked your no zone. I have it on my phone. Perfect. All right, if we could have a
Thank you.
staff report, this is Victor Cornelia, our former planning director, will give us a report on this.
And now
item.
consultant. Thank you, Chairman, members of the commission. With that as the attorney did a thorough preamble on the procedural context in terms of acting on this item. I think it's important for everyone to understand the item that's currently before the commission to really have a good feel for the background of this item, the historic background. And really the origin of this agenda item dates back to not the current housing element, but the city's previous housing element, the 2009 to 2014 housing element, which was adopted by the city back in 2009. And in that housing element, the city agreed, and there was a policy in it, whereby the city committed to make multiple family housing a permitted use in the entire medium and high density zones. That's a significant distinction from where we stand today, simply because at that point in time, and still does currently, the medium density zone covers a good portion, the bulk of the city's existing single family neighborhoods. So moving forward then to 2015, when the city updated its housing element. And with that housing element update, and this new housing element is good for an 8-year term from 2015 to 2023, the city was able to negotiate with the state, essentially, for the city to get a housing element approved. And it's different than other parts of the general plan. The city also needs to get the concurrence of the state HCD. And essentially, the city was able to negotiate the fact that instead of the multiple family housing being a permitted use in the entire medium density zone, which, as I mentioned, covers most of the city's existing neighborhoods, HCD was agreeable to a compromise where only what are known as the key housing sites, or the housing opportunity sites, were the only ones where the city had to commit to make multiple family housing a permitted use in those, in terms of the medium density zone. So essentially, where the city went was under the old housing element, it would have covered, in terms of multiple family being a permitted use, roughly 430 acres of the city, with now it only being applicable to the key housing sites, that only applies to 40 acres. So it's a significant change, but in any case, it is an obligation of the city. And in addition to the multiple family designation in the medium density zone, the city also agreed in the housing element to make it a permitted use in the high density zone. So what really is the commission has before them are those two actions as they relate to making multiple family housing a permitted use just on the 7 opportunity sites in the medium density zone and in the high density zone. And in a sense, or literally, the commission's in a bit of or the city's in an unusual situation in that essentially the city committed to this decision back when the housing element was adopted in May. Planning Commission, I believe it was on May 7th of 2015, adopted the housing element. So essentially, when that housing element was adopted and council adopted it toward the end of May, I believe it was May 26th, the city committed to make those changes. So those are the changes these changes are the ones that are currently before you. The net result or implication of that is the city does not have a lot of discretion in terms of its ability to say, for example, no, we don't want to make multiple family housing a permitted use in the high density zone. That's essentially that ship's already sailed in terms of what was approved in the housing element. And as it relates to the housing opportunity sites, which were selected as part of the housing element process, the city really doesn't, at this point in time, have the opportunity to pick and choose between those and say, well, we think this side, it makes sense as a permitted use, but not on this side. Essentially, the decision in terms of those 7 key opportunity sites was decided back last year. So this is kind of an unusual decision that or an unusual item you have in front of you. Just compare it to the previous item where clearly the playing field is wide open in terms of the city's ability to make changes to the short-term rental ordinance. And in this case, it's much constrained. So with that as a preamble or background, staff would recommend that the Planning Commission recommend approval of the changes as contained in the staff report to the City Council, and this item is tentatively set to go to the City Council at the end of April. And as the City Attorney indicated, the housing element does have a hard deadline in this, which is May 31st of this year. So I'd be happy to answer any questions if you have any.
Yeah,
Please keep your questions to the items that you don't have to recuse yourself to. And if we do start a discussion on the locations, okay, just making sure.
I just want to know if
I have to give the caveat still.
Sure. Thank you. I wanted to know if the ship that sailed it was mandated by California state law to sail, was it not?
It was indeed. As I indicated in my presentation, the city was able, with the new housing element, to negotiate a much better situation from the city's point of view in terms of the city retaining discretion. As I mentioned, in the medium density zone, previously under the 2009 to 2014 housing element, that would have applied to 430 acres of the city. Under this change, with it being limited to the opportunity sites, it's approximately 40 acres, but that ship did sail last year.
Yes.
Would you tell would you explain permitted use to me, please?
It's a good question. The city, maybe the best way to explain it is in making the change. The primary modification is to eliminate the use permit requirement.
That's what I thought. I just wanted to be sure that I've understood that. Thank you.
Can I?
I see that our city attorney has a statement to make.
I just wanted to elaborate, if it's appropriate, on what Mr. Cornelius said about the constraint of the city's discretion in this regard. And typically, I am really a pretty staunch advocate for the breadth of your discretion and the breadth of the police power and your ability to make policy decisions. This is clearly an exception to that. This is an area where the state has really clipped locals' wings. Because the Housing and Community Development Department is tasked with the responsibility of certifying local housing elements, when they impose conditions on us, those are really strict mandates that we have to comply with. And the consequences of not complying can be really dire. An example is pretty infamous, but the city of Pleasanton several years ago confronted this and opted for a lot of different reasons not to comply with one of the commitments they had made in their housing element. And that factor, combined with other factors, led to the state of California, as well as affordable housing advocates, suing Pleasanton and suing successfully. And the result of that was a court order that stripped the city of all of its permit discretion for an extended period of time until the city, in that case, was able to reach a settlement with the state and with the affordable housing advocates. And the situation there is very, very similar to the situation before you. I think it's also important for the Commission and the city to be recognizing that we recently have been under the microscope here in St. Helena with respect to affordable housing, and in the Calderon lawsuit, the city was really under that microscope, and it led to expensive litigation and an expensive ultimate settlement in that case for the city. We know that the affordable housing advocates still have St. Helena in the microscope, and so it's my recommendation that this really is an area where there is little or no discretion. The city needs to do this, and if we opt not to, there likely, or there can be, as I said, very dire consequences for St. Helena.
Thank you.
I have a question. My understanding is I just want to understand better that with this change is that the CEQA impacts from use will no longer be apply for in the high density and on the opportunity sites. However, the CEQA impacts from design will still apply. Can you tell me what the difference is? What the difference in those impacts are? I mean, are they the same? Are they? But yeah, I would like to know what that means.
It's a good question, and they are somewhat different. And getting back to Commissioner Kisner's question about the distinction of a permitted use. So with a use permit, you have a number of findings that have to be made to act on a use permit. And in doing the CEQA for a use permit, the range of analysis is in breadth is the full range. In the case of a permitted use, the way the city zoning is set up, any new building that comes in beyond a certain size, but more for all practical purposes, any new building that comes in has to go through the city's design review process. Simply because it has to go through design review and a use permit's not required doesn't exempt it from CEQA. So the project would still have to go through CEQA, although in doing that, we would have to be careful to tailor the level of CEQA analysis to the level of the city's discretion. So that would, for example, if in doing the CEQA, you'd be looking at, what's present on the site, if there's any biologic issues, all those kinds of things. Clearly, visual impacts, impacts arguably even of noise you would get into. So, and really, to some extent, it would depend on the scale of the project too, because as the project scales up, the impacts can get broader. But I guess the short answer is CEQA would still apply. There really is no general answer to it. It really would be case by case, but discretion or the breadth of CEQA is limited by the breadth of discretion the city has.
Meaning what the city decides to demand? Is that what you're
Yeah, let me, Tom here, I can clarify.
I think a much shorter way of looking at it is the scope of the CEQA review under design review is much more narrow than the scope of review for a use permit. You wouldn't be looking at traffic. You wouldn't be looking at the kinds of land use impacts that are associated with uses, as opposed to simply the aesthetics of the building design.
So what CEQA things, that's what I would like a comparative, what CEQA things are allowed to be looked at under design review? Obviously, the sewer, the water, the traffic, none of those are. So what CEQA issues could be? I mean,
Well, and I think you'd be looking at aesthetics, and I think irrespective of the fact that you're focusing on design, I think if there were any on-site issues, if you had some, wetlands, endangered species, those kinds of things, I think you would still trigger those aspects of CEQA. But as the attorney indicates, any impacts that kind of get away from the aesthetic part of the review, then you wouldn't be addressed CEQA-wise.
so impacts on infrastructure and that sort of
Right.
thing. Okay, thank you for clarifying.
Any other questions?
Can we just talk about the design review? I mean, I find that very discretionary. And so is the intent that the next step is these design guidelines that'll make it less discretionary?
In adopting the housing element, staff or the city also made commitments to establish design guidelines with the ultimate direction of eliminating the design review process as well. Whether we ultimately get to that level or not, we're going to have to see, but we have committed to establishing design guidelines that would guide future development and design of multifamily projects throughout the city and including on these sites.
So you couldn't arbitrarily just, I don't like it, there would be some substantive.
Well,
things.
yes. So some of the challenges that are being kind of driven down by the state are in response to communities who utilize design review to deny projects that they are not interested in supporting, such as affordable housing projects. So while cities are granted discretion in land use, the state is essentially ratcheting down that discretion in multifamily or apartment projects because cities, frankly, are, from the state's perspective, abusing their discretion in the question of use versus design.
One more question. Is density considered a design review CEQA issue?
Only to the extent that there's a massing issue, but the short answer I'd say would be no.
That's right. They're having that problem with when they're trying to build in Santa Rosa right now, near College Avenue over there.
Yeah. Any other questions? All right, so I think that how we're going to do this is there will be 4 motions this evening on different items, and I'm actually going to start with the motion that all of us can be in here for, and then we'll have a discussion on the item. I'm going to do the addresses.
After we open the public hearing.
Oh, I'm going to open up the public hearing for the addresses. So it's just, I'm going to list off the addresses so that people can stay in here. So I'm going to open up, this will be the item, no, you get to stay in here, is going to be for, let's see here, 1817 Spring Street, Sulphur Springs Avenue, APN 009362015, Spring Street, APN 009441023, and 009552002, and then Pope Street, 1105 Pope Street. I believe we can all be in here for. So, if we could open up the public hearing on discussing these identified sites by the city as
And these are the housing opportunity sites.
these are the
designated.
housing opportunity that the city has designated. Those are the addresses. Would anyone like to speak at public hearing on those addresses?
My name's John Valerga. I live on 1984 Magnolia, and I'm also apartment owner. I'm not anti-apartments. I'm apartment owner in Santa Elena, 3 different properties. I'm real concerned about a high-density multi-family project on Sulphur Springs. That road's a mess. I walk it every day. There's no sidewalks. There's no place to walk. And when you have a multi-family, you're going to have kids there. They're going to have bikes. I feel really bad about them, going over to the primary school, going over to Crane Park, going anywhere. I mean, it's a suicide mission. It's posted 25. It's usually 45 or 50 that people are traveling down that road. Unless the road, I wouldn't have a problem if the road was improved with sidewalks and bike lanes, but the condition it is now to dump a large multi-unit apartment complex there, I think would be not a good choice for kids.
Thank you.
That's it.
Thank you. This is it. We're doing it item by item. No, because we have to break it down because you have to recuse yourself, Grace has to recuse herself, and so I have to just do it by all the separate addresses. Go ahead, I'm sorry.
Hi, my name is William Wagner. I live at 1160 Hudson Avenue, and Opportunity Zone 3 is directly behind my house. I just have a couple of questions. One, you guys weren't really clear about how these opportunity zones were chosen. I understand that the state kind of strong-armed you guys into choosing things, but how did you choose them, and when were they chosen? Was there any public hearing on that at all?
Yeah, I can jump in on that. They were, the state requirement for the housing opportunity sites, I believe, came as part of the third cycle update. So I haven't been with the city that long, but opportunity sites would have been chosen as far back as 2000. Once you tend to choose a site, it's difficult to back off of one in terms of from the state's point of view, and they do look at criteria in terms of the site. You know, it's being, typically they're vacant sites and have utilities, etc. But a lot of times the sites, some make sense, some don't make sense. In any case, I believe it evolved sometime in that time frame, and is when we did the housing element update most recently in 2015. Those sites were again reviewed, and there were public hearings on that. But essentially, what you're largely looking at is a carry forward.
Okay, because I'm directly affected, and I got no notice of the 2015 hearing at all. Literally 2 days ago was the first time I heard this was ever happening. And my second question is so if they do have high-density housing, how high density are we talking? Are we talking 2- and 3-story apartment buildings? Or are we just talking houses?
Well, it's the density in the medium density. Density is limited by the maximum allowed in the zone. In the medium density, it's 16 units an acre. There is a thing called state density bonus law that can allow numbers to go a bit above that. But essentially, you're looking at the range from 16 to 20. As a rule of thumb, typically 16 units an acre, 16 to 20 is typically a 2-story unit. When you go into the 20 and above, 25, typically it's a 3-story and more unit.
Even in a 2-story unit, it's going to be looking right into everybody's bedroom and right into our backyards. So I can't believe there was no better notice about this. It's really disappointing. That's all I have to say.
Sorry about that.
You get a shot at it.
Hello, I'm Pat Ansley. I live on Olive, and one of the parcels is right behind me. I'm wondering if the owners have agreed. I know the owner of the property is not interested in selling his property, so how is his property included? Have you been talking to the owners?
Now, that's an excellent question, and during this issue comes up or came up during the housing element process. The state really does not take into account the wishes of the property owner or the intent of the property owner. You would think if you're looking at projecting as to what sites would likely develop for any sort of use, one would check with the owner, but that is not part of the state's criteria, and so that's not considered in selecting the opportunity sites.
So does that mean we're talking about eminent domain?
No.
No, the opposite. No, we can't force them to do this. It's just that a site was identified as a key possible site if the owners should so choose to sell it to a developer to do that kind of housing.
Yeah, maybe I should clarify. For something being designated a housing opportunity site simply means it's a way, in a sense, of doing accounting to see that because the state obligates the city to produce a certain number of units over a certain time frame. If you look at the opportunity sites and then total up the numbers of units, then the state can get some sort of benchmark as to how close or how far the city in question is in terms of complying or not complying. But it carries with it no obligation to develop the property.
When we bought the property in 1998, we were told that that vineyard was part of Ag 20. And we checked with City Hall, and they agreed that it was part of Ag 20. So this is Qualia's vineyard. So I'm not quite sure how you go from Ag 20 to being on the building.
Is this the Sulphur Springs property?
No, this is the 1817 Spring Street.
No, yeah, 1817. No.
No, it's the one.
No, it's one without an address.
Okay.
It just says Spring Street and 2 parcel numbers.
Okay, right.
Yeah, and when I went on to find out it on the parcel, from the parcel, it wouldn't give me the name of the owner or the address, just said it was 4.39 acres, which just fits Mr. Qualia's vineyard to a T. So, and the final one, is this coming up partly because over the years we haven't been able to agree on affordable housing sites and so forth, and so we've,
Oh, it's fine.
So that we haven't been able to agree, and now the state's stepping in?
No, it's nothing that heavy-handed. It's simply the city needs to the city committed to take certain actions as related to properties, and so the city's now doing that. Cities all across the state are doing this very similar kinds of things. So St. Helena is not being singled out by the state.
Right, but I'm still curious about how something that was designated Ag 20 is all of a sudden a housing site.
No, it was in the 93 plan also, and I think it was also in the 77 plan, if I remember correctly.
Oh.
I think so. I'd have to dig the 77
We
plan out.
actually went down to City Hall, and we were told, yes, it was part of Ag 20. So somebody gave the realtor and ourselves wrong information. I don't know.
And once again, there's no obligation, and frankly, to develop the site, it would have to comply with all the city's land use requirements, and if those are ag, then they would have to get that changed. So.
Okay. Well,
They'd also have to get permission from the person that owns it to buy it. So it's...
Okay, all right,
Yeah.
thank you.
Yeah.
All right. Would anyone else like to speak on the addresses I listed off before? All right. Seeing none, I'm going to close the public hearing and invite commissioner discussion. Any discussion? All right. I am going to ask for a motion and read off the required how this needs to be done. I am seeking a motion to adopt the described amendment to the St. Helena Municipal Code related to multifamily housing to allow multiple family housing by right to, bear with me, I'm so sorry, 1817 Spring Street, APN number 009, ending in 009, Sulphur Springs Avenue, APN number ending in 015, Spring Street APN number ending in 023 and 002, and then 1105 Pope Street APN number ending in 003. Do I have a motion?
So moved.
Do I have a second?
Second.
Roll call, please. That was a motion by Monette and a second by Kistner.
Commissioner Monette,
Yes. Yes.
Vice Chair Kistner,
Yes.
Commissioner Koberstein,
Yes.
Chairperson Parker.
Yes. All right. Moving on to our next one. Commissioner Monette, would you like to recuse yourself on this one?
So under the
This next-
rules, the recusal, the member recusing him or herself is required to actually identify the
Would you like to identify
financial
why you're
interest.
recusing
So
yourself?
you need to identify that you own real property at a certain location.
Yeah, which property is this?
It's the 567 Pope Street and 591 McCorkle.
Yeah, I own property on McCorkle Avenue that's very close to these two addresses.
Thank you.
You can go in the back or the hallway. So again, I'm going to open up the public hearing as soon as Commissioner Monette is in the back room, and this is for 567 Pope Street and 591 McCorkle. Would anyone like to speak on these two addresses? Seeing none, I'm going to close the public hearing and invite commissioner discussion and motion. Seeing none, I'm going to seek a motion to adopt the described amendments to the St. Helena Municipal Code related to multifamily housing to allow multiple family housing by right to 567 Pope Street and 591 McCorkle. Do I have a motion?
Second.
Thank you. That was Kistner and Koberstein.
Vice Chair Kistner,
Yes.
Commissioner Koberstein,
Yes.
Chairperson Parker.
Yes. I'm going to ask Commissioner Monette to rejoin us and ask Commissioner Kistner to recuse herself and give her reasoning for recusal. This is 576 Pope.
I recuse myself because of 567 Post Street.
76.
576. Excuse me. I'm not sure that I have.
All right. And I'd like to open up the public hearing for 576 Pope Street. Would anyone like to speak on this address for this item? Seeing none, I'm going to close the public hearing and seek a motion to adopt the described amendments to the St. Helena Municipal Code related to multifamily housing to allow multiple family housing by right to 576 Pope Street. Do I have a motion?
So moved.
Wait, isn't it? Oh, yes, I'm sorry.
Yes,
That's the
it's
right
inverted
address.
numbers.
Yeah. That's so moved.
Second.
That was Koberstein and Monette.
Sorry.
Commissioner Koberstein,
Yes.
Commissioner Monette,
Yes.
Chairperson Parker.
Yes. And with that, I'd like to invite Vice Chair Kistner to rejoin us, and then we are going to be moving on to the high-density locations, and we will have to invoke the rule of necessity and draw straws. Commissioner Monette and I will, because we live in a high-density area. We are zoned high-density, so we are.
Very scientific.
Yes. Oh, you're just going to read this.
We should have, with the chair's
here?
permission, we should have an agreement as to who wins or who loses.
All right.
The shorts.
I will leave that to Xenia can decide if the short stick or the long stick gets to stay in the room.
How's their choice?
We'll do the long stick.
Stays in the room. Okay.
Stays in the room.
I'm seeking a motion to adopt the described amendments.
I can't stand it.
All right.
I have an anxiety disorder.
All right. Is that the long one? Okay, perfect. Don't we get to see the other one? Oh, yes, why don't you show the, yeah, okay, I'm staying. Good. We have other agenda items. So we have other agenda items, but I won the long stick. I'm going to ask Commissioner Monette to recuse herself again due to the fact that she lives on property that's zoned high density.
Yes, I am recusing myself because I lost.
All right. So now I'm going to open up the public hearing on this. Would anyone like to speak on the high areas zoned high density? Do we have a high density map?
So there was some discrepancies on that map. However, the high density sites are accurately identified on it.
Right.
All right. Why would you need them side by side? Well, the other sites were medium density, so they're not going to be in red.
High density or the red ones?
High density is the whole zone.
Yeah, it in this case it really doesn't matter because the entire all properties in the high density zone, whether they're opportunity sites or not, multiple family housing is going to become a permitted use. So whether they are opportunity sites or not is not material.
So would anyone like to, if you could come up to the microphone so people at home can hear it. Thank you.
Then just one more question. If you could be specific about where the location on the map where opportunity site number 3 and number 6 are?
And 3 and number 6 were 576 Pope Street, and 3 was Spring Street. I'm going to guess that Spring Street is right here, that in that area. Yep. And I'm going to guess that Pope Street is up there. I'm not tall.
Oh, I'm sorry, number 5.
Number
instead of
5
number
is right
6.
here.
Okay, so both, you're confirming both in medium density.
Yes, they're both medium. They're
Wonderful.
not high density.
Thank you.
Excuse me, can you state your name, please?
Of course. My name's Jessica Haig. I'm a resident of 1154 Hudson Avenue.
Thank you.
Thank you very much. Would anyone else like to speak on this agenda item? Seeing none, I'm going to close the public hearing and invite commissioner discussion. And now I'm going to seek a motion to adopt the described amendments to the St. Helena Municipal Code related to multifamily housing to allow multiple family housing by right to the to the high density residential sites citywide.
Okay. So moved. Second.
So that was Kistner and Coberstein. So Coberstein and Kistner.
Commissioner Koberstein?
Yes.
Vice Chair Kistner?
Yes.
Chairperson Parker?
Yes. Thank you. I'm going to ask Commissioner Monette to rejoin us for the remainder of our agenda item, and thank everyone thank you for coming. That was it. Mm-hmm. All right. Moving on to our next item on the agenda, department report on our department activities.
Just briefly, first I want to thank the commission for struggling through that with us and the public, both in the room and at home. I know that was a challenging item, and the procedural, and the city attorney and planning consultant Victor Carniglia for being here, as that was a procedurally challenging item and somewhat deflating issue given the fact that it takes away a lot of the local land use authority that we have.
I would like to add, though, it's that initially the state wanted all of St. Helena to be able to build anywhere. So your neighbor could have sold their house and put a 3-story house next to you. So the fact that it's itemized, yeah, it's fine. It's the fact that it's itemized locations, it gives St. Helena a little bit more control. We didn't completely lose.
But I can't say anything.
Yeah.
Can I say
No,
something?
because I've already closed the public hearing.
So, I'm just wrapping up with the department report. So we are finalizing the general plan, which has been in the process for over 10 years and spent over $1 million on the process. And we're finalizing the general plan right now. Staff's reviewing an administrative review, draft. We were initially shooting for a study session with the commission on the 19th of this month. We may not be able to get there because we're trying to make sure all the graphics and text is fully reviewed and eliminate typos, et cetera, et cetera. So if we do not make the 19th, we will be having that study session with the commission on May 3rd. There will be no decisions made at that meeting. However, we are moving that process forward, so it'll be first blush for the commission and the public for the finalized version. And I will add, kind of in the vein of this conversation, we are proposing to reduce the density on a number of sites that are currently designated medium density in the city to address some of the concerns that we're hearing as a part of these issues, given that, we're trying to preserve historic development patterns. We're trying to make decisions that are palatable for a lot of the community members here. And so we have initiated a proposal to reduce density on a majority of the sites in the city. I wouldn't say to balance some of these requirements, but it will seek to do that in effort, at least. And we do encourage all citizens to participate in that and review that document and provide their comments to staff as they're able. We are also kicking off the budget season, so we have lots going on at City Hall, but we're trying to finalize our department budget as well as the city budget in total, and that will also be coming back before decision makers at the council level. There's also a document called the Agenda Forecast in the Planning Commission packet, and we're including in Planning Commission packets moving forward. It identifies all the things that we're working on currently in our department and kind of future things that we know we will be working on. So I'd encourage citizens to keep an eye on that. It lets folks know what's in the pipeline and what will be coming before the commission for review and action. So thank you very much.
Can I just ask a question? Are we going to get a hard copy of the plan
so that we don't have to read everything online?
We're currently scoping out the cost of enough copies for every commissioner and every council member,
Thank
and
you.
to have some available for the public to purchase and thumb through at the counter.
Thank you.
Perfect, thank you. All right, agenda forecast.
So nothing.
I guess you kind of
nothing
did that,
specific
but
to add to, but yeah, just identifying that it's there. There's lots on it. Department activity is remaining strong. It remains strong throughout the winter season, and we expect probably this year to be similar to last in the amount of applications that we were processing.
perfect. Thank you so much. And with that, this meeting is adjourned. Thank you for joining us this evening.